All doctors have an ethical and legal duty to ensure their patients' medical records are kept confidential. That said, medical records can be seen as an important source of information for both patients and doctors involved in various legal proceedings or claims. You may, for one reason or another, receive requests to disclose your patient's clinical records. Avant receives many questions from doctors who are unsure of their responsibilities when these requests are received. The medical record is all of the documentation of the patient's care. This includes both handwritten and electronic notes, test reports, specialist letters, certificates, photographs, x-rays, discharge summaries. Sometimes, specialists write to general practitioners stating that their letters should not be supplied to third parties without their consent. However, the letter forms part of the patient's medical record and, like any other element of the record, such as your personal notes or photographs, the patient has the right to access it. You should not include in the medical records any correspondence with Avant or any complaints you have received from the patient. These documents should also be stored securely, but in a separate file to the patient's clinical records. When a request is received from a third party to release medical records with the patient's written consent, it is generally appropriate to provide copies of records to that third party. When you receive a patient's written consent or authority to release medical records, you should read the authority or consent form carefully to ensure that the documents requested are within the scope of the authority or consent provided. Ensure that the patient had sufficient capacity to consent to the release of records, sign the authority, and understand the effects and consequences of records being disclosed. Ensure the written authority clearly indicates who the records can be released to and which records are covered by the authority. Ensure the authority is signed by the patient and is up to date. If you have any doubts, telephone the patient to clarify. If you receive a patient's verbal consent to release records to a third party, then you should carefully document this and go through a number of the steps previously mentioned. For instance, ensure the verbal authority clearly indicates who the records can be released to and which records are covered by the authority. On occasions, a medical practitioner may be required to release a patient's confidential health information without the consent of the patient, where the use or disclosure of the information is required by law. This compulsion by law includes mandatory legal disclosures such as receiving a subpoena or a warrant. It also includes a public interest exemption, such as when a serious crime has been committed or there is a risk of serious harm to the patient or to another person. So, for example, it is unlawful to disclose or release medical records in response to a letter from a solicitor requesting records without the patient's consent. However, if the solicitor's request is supported by a signed authority from the patient or a subpoena from the court, indicating a legal compulsion, then the records should be provided. Some states have specific legislation relating to the collection, use, disclosure and access to medical records. Nationally, there is the Privacy Act and Australian Privacy Principles. It is not always straightforward, so if you have any questions, you should always contact Avant for further expert advice.